the money to move. How did we do this? We have remodeled the business structure, a lot of it centered around our locals market. We have also secured a line of credit with a local lender, and we've trimmed the budget in half. We're going to use the engineered prefabbed offices and restrooms, and this is going to save us big, big money. This is what the schools do when they need extra classrooms. And folks, we can move now, and those plans are very easily and readily available, so we can hit our 50% plans very quickly. But again, we got to figure out our site plan. And what I mean by that, if you'll look here, the site plan, I wanted you to note all of the parking that is required. The layout here is not final. These are just here to let you know these are the different functions that we envision here for our agriplex. My feasibility expert has said, Casey, you're going to need about 50% of the land for parking. He's estimating about 3 people per car. Our big event of the year is the fair. So if you think you have 15,000 people a day, that's 5,000 spots right there for 3 people a car. And then, of course, we have our amphitheater and our exposition hall and all these other things. But the parking, I hate to say it, this is still an issue for us. And this additional land that we're looking for is going to greatly help us, as you can see, to locate the fair. In the upper right-hand corner, I also wanted to touch base on something else. You'll see an RV park up there. And with that, I want you to let you know that it is an ancillary use to the fair. So our vendors need it during Fair Week. We might have it for the exhibition hall. If there's a 3-day weekend event, somebody could stay there. Same thing with the amphitheater overnight. It's all going to be ancillary. It will not be for grandma and grandpa or mom and dad, anybody to come down and snowbird there for the season and stay there for 6 months. It's ancillary and temporary. These are my counterparts across the state. All of them have RV parks at their fairgrounds, and you can see it's anywhere from 40 in Pasco to 500 in South Florida Fair. We're envisioning around 75, give or take, spaces. So why do we need more land? Parking, 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 parking. I know it sounds familiar, but I'm asking you today to please help us build it right this time around. We will be an asset not only to Martin County, but the entire Treasure Coast, but we need your help to ensure our success and sustainability. Where does the project stand today? We need to know our footprint to proceed. I've had 2 meetings with South Florida Water Management District. Commissioner Campy, thank you. You attended the first one with me. He understands a lot of the issues that we were faced with the fairgrounds through that meeting, and I appreciate your support. I also then went down and met with Drew Bartlett, the executive director, and it was very exciting because they are very much ready to engage with the county if the county will engage with them. And they have thousands of acres around this parcel, and they want to put in walking and hiking trails. And they said, this would be a wonderful asset for us because we need parking and we need a trailhead. So this would be a fabulous collaboration between Martin County, the fair, and South Florida Water Management District. It's something we all can use together. So that was the conversations I had with them. And again, they are ready and willing to engage with the county. So what am I asking for today? I'm asking for you to stand with me today and help remove the obstacles that's preventing our progress. South Florida Water Management is open to collaboration with the county, and I believe together we can create exceptional amenities for Martin County that will benefit future generations. We appreciate the support we've received so far. That included the 84 acres already, as well as providing essential infrastructure that you have done. However, in order to offer these amenities and avoid parking issues that we currently face, we need this additional land. South Florida Management is eager to cooperate, and they will benefit with their facility as well with the walking and hiking trails and the trailhead. So I'm hoping today that we can work together to make this vision a reality. Thank you. Do you have any questions?
Ms. Mullins, thank you very much. You're so articulate, you should probably have like a radio show or something. You really have
Think about that. Thank
really
you.
professional sound.
Great idea.
A couple of quick things. One, thank you for the presentation. Not only for my colleagues and our staff, but for the public that gets to see this. A lot of people, we talked about the fair for a long time, several years ago. Jay Spicer carried the weight of this new vision for a long time. I think the Fair Association was smart to pick you to now take the lead. They get a 2-for-1 with Tim, who comes along with the package deal like you mentioned, so I think that's important. I feel renewed and re-energized that we're close now.
We are.
And not the boy who cried wolf anymore or anything like that. I mean, to Jay's defense, there was a global pandemic and some other things that sort of swept away some of his opportunities. The other thing that you didn't mention that I know a lot of people would see as a huge benefit in association with the fair is the possibility during hurricane and storm season to not only bring out our residents that can store things, boats or RVs or our key equipment, the sheriff's key equipment that we don't necessarily have fortified locations to store during an emergency. We also have the ability, a lot of us have had the opportunity to see FPL mobilize at our airport. And then they can do, I spoke to a couple of my friends at FPL, they're looking for something that they don't have to quickly pull it out. The other advantage is if you created a pet-friendly shelter here, it could last a little bit past the storm versus when it's in a school, they instantaneously have to remove everything that made it as pet-friendly. And I know a lot of our employees have participated in that. And then when the storm rolls past, they're this mad dash rush to return the school back to what it looked like beforehand. That could be handled out here. I know that when I spoke to friends that have horses that basically either have to, release them, or as you had mentioned, they either with a magic marker write the identification directly on the horse or shave a phone number into the horse's fur and just let the horses just fend for themselves during storms, whereas here they could stay in a secured facility. All of those things on top of everything else you mentioned, if anything, I think it becomes mind-numbing with all of the possibilities. So with that, the last thing we'd say before we move on, and thank you for the presentation, is that the reason there is an additional ask for some additional 40 acres potentially is that when we peeled some of the original acreage away for the school, which I think creates excellent synergy because it's a vocational school, and a lot of what you're doing with the Agplex is vocational. That's a beautiful marriage. The thing that when you had said to me originally, hey, we need more space, I was a little concerned, but your answer, which I think was excellent, is you've already spent thousands, tens of thousands of dollars to design, $200,000 to design a footprint that now with that extra space, you literally could leave it the same and slide it over. Otherwise, you got to basically start from scratch.
We do, and we'd have to decide what we're going to cut out of our plan, and that's the thing that breaks all of our hearts, is something would have to either be removed or downsized. Of these I think all of the uses I talked about are something that is going to be here for generations for the community to use.
Okay, so I think you've informed my colleagues and myself and our staff to what is the next step, and so we appreciate that presentation very much.
Thank you for giving me the opportunity.
Any questions for the fair? Seeing none at this time. Thank you very much. Thank you, Tim. Okay, we're going to take an item that we had heard at our last meeting. It is public hearing number 1, a legislative public hearing to consider adoption of a comprehensive plan amendment, CPA 23-05, 6900 Southeast Ridgeway Terrace. It'll be presented by Mr. Clyde Doolin and Miss Elise Elder.
Good morning, members of the board. My name is Clyde Doolin. This is a legislative public hearing that was continued from September 12. It concerns a 0.65 acre parcel of land at the corner of Ridgeway and U.S. Highway 1. The first public hearing was held before the local planning agency. The local planning agency voted 4-0 to recommend approval of this proposed change. The applicant is seeking a change from the mobile home future land use designation to the general commercial future land use designation. Staff's recommending approval. Advertisements were done in preparation for the September 12 meeting, and it was continued to this meeting, so no additional advertisement was necessary. This is a location map showing the parcel. This is Publix to the south. This is a dealership to the north. The deals in recreational vehicles. And this is the existing future land use that's assigned, mobile home future land use on the property. As you can see, there's general commercial to the north, general commercial to the south, general commercial to the west side of US 1, and this medium density residential you see where my cursor is in a preserve area as part of a subdivision approved. This is the proposed future land use, general commercial on the subject site. As I said, staff recommends approval. This is a legislative public hearing. It is the adoption public hearing of for the proposed amendment. And with that, I will be happy to answer any questions.
Thank you very much. Questions for staff? Seeing none. Applicant?
Good morning. Mike McCarty, McCarty and Associates, Land Planning and Design, representing the applicant. Address 309 Southeast Osceola Street, Stuart, Florida. Pleasure to be here. Appreciate the opportunity. As staff indicated, we submitted this future land use application. We've demonstrated compliance with the requirements of the future land use amendment process. Staff has reviewed our application and our justifications, our traffic, and many other requirements, and deemed that we are in compliance, and they have recommended approval. We were before the LPA, and they recommended approval as well. We were before you on the 12th, where there was some concern. I believe we've addressed those concerns. Notices were sent out to adjacent property owners. The appropriate signage was posted on the property, and those affidavits I've submitted previously on the record. 188 notices were, in fact, sent out. Of those 188, I had 2 phone calls with individuals that received the notice. It was more informative, explaining them the nature of the application and the intent. They had no issue. I then did have 1 call with a Tom Quint, who lives 3 lots down on Ridgeway, 3 lots to the east, if you will, on Ridgeway. Mr. Quint was adamant about the land being used for mobile homes. Come to find out, Mr. Quint was a bidder at the auction when this property was auctioned, and was not the high bidder, but was an active bidder trying to acquire the property. The fact is that mobile home is not appropriate for this parcel. You have Publix to the north. You have Broward Motorsports to the south. This is a corner at US Highway 1 in Ridgeway. The site was previously used for a fire station, so there's an existing structure and improvements on the property. My client acquired this property and intends to reuse the existing structure at this point in time. Going green, let's reuse the structure, right? And in fact, the tenant that they are working with to place in that building is Worldwide Clean Water. And Worldwide Clean Water is a green industry. They provide filtration systems for water, and they are active in the fight for clean water and filtering PFOS from the groundwater and such and other contaminants. So what we're doing here is we are doing something good for the community. We are reusing an existing building and facility, and we are putting a green industry business in this building. Very low impact in comparison to the previous fire station. So with that, I respectfully request approval of the land use amendment. If you have any questions, I'm happy to answer them at this point in time.
Mr. McCarty, thank you very much. Questions for the applicant's representative? Seeing none at this time, I have several request to speak forms. As I mentioned, you'll have 3 minutes to address us on this topic. And so we'll just call them. There's not so many. I'll just call it. Yes, sir.
If I may, sir, I also have my team here. I apologize for that interruption. I also have my team here. I have Jared Gaylord, our legal counsel. I also have ownership here, and, as well as some other individuals. Jared, would you like to make any additional comments?
Good morning, Commissioners. I don't need to make any additional comments at this time. If I could just reserve any rebuttal time, I don't know the procedure for that, but if I could reserve some time to address some of the neighbors' concerns, that would be appreciated.
Play it by ear. Thank you, sir.
Thank you.
Our first request to speak form is Ms. Doris Smith. Ms. Smith, good morning and welcome.
My name is Doris Smith, and I live on Swan Avenue around the corner from Ridgeway. And in fact, I was the first person I managed the clubhouse office for 10 years. And I received a call from the county telling us about this pending sale of the property. And I was advised personally that we have our sign. This is the main entrance to Ridgeway, which is a community of almost 900 lots. So there's well more than 800 people here. And this is the main entrance to our community, which has been there since the 60s. And until 10 years ago, it was a 55-plus mandatory HOA. Well, in a court case, we lost that. However, we have a lot of elderly and we have a lot of children in there now. And this is, as I say, the main entrance off of US 1. The other main exit is onto A1A, the Dixie Highway. And so it states where we are. But I was advised that we would be granted a permanent easement to keep our sign there. But I was also contacted by the lawyer, and it might have been this gentleman, Mr. Gaylord, that asking us if we would remove the sign. And, of course, where would we put it? We have no way to identify our neighborhood. And, and I know that the person who bid on the property was looking at it to make it a residence. Thought it would be a really cool house to live in, not necessarily being a mobile home there, but, but it's a big concern. And already I've personally seen vehicles. I was driving down Ridgeway Terrace going to US 1, and I thought the road was blocked. There was this giant trailer moving into that property, all lit up, and it was blocking the entire street. I mean, I was alarmed. I didn't know what it was. And so already there's a lot of traffic there, and it's just a concern. There's kids playing in the street, and we just hate to see our neighborhood just eliminated. Who's Ridgeway? Nobody would even know. And so that sign has absolutely got to stay there no matter what. But thank you for your time.
Thank you, ma'am, very much. Our next request to speak form is Matthew Hendrickson.
Mine, I'd like to give my time to the next citizen.
Well, you can forfeit your time, which is fine. Everyone gets 3 minutes. You can't bundle it, but thank you. I understand. Our next request form is Miss Patty Allen. We're okay? Our next request to speak form is Miss Peggy Lagotte. Ma'am, good morning and welcome.
Thank you for this opportunity to address you. I also share the job in the office. I worked in the summers when Doris was a snowbird. I also have served on the board of directors for about 10 years now. And I'm concerned, first of all, that the lawyer said that 188 notices were sent out. I don't know of anybody in the community who received one of those notices. There was a notice sent to the clubhouse, and I think that the county may be under the impression that this is still an HOA, and that everything that's sent to that clubhouse goes out to all the residents. But it in fact doesn't, because it's no longer an HOA. It is strictly a social and recreational club, and attendance and participation in it is totally voluntary. So we have like 200 members, and there are over 800 people living in this community. Also, this community has been here for a very long time. Our sign was there before the firehouse. And as I said, we have switched since there's no longer 55 plus. We have kids. It's a very dangerous situation there to have it already. The traffic has increased. It used to be that you could only turn right there. Now they're turning left and right. The residents are already complaining that they have all the trucks coming and going from Publix and the noise at night. So they are really being put out. So anyway, this is not a good fit for our community at all, and I don't believe that we received proper notice. Thank you for your time.
Thank you, ma'am. Our next request to speak form is Mr. Tom Quint. Mr. Quint, good morning and welcome.
Tom Quint, 6940 Southeast Ridgeway. You had postponed this vote, whatever, for 2 weeks to allow their attorney and stuff to reach out to me. He spoke to me outside and said, "Can I get your name, your phone number, everything?" They did not respond at all. I didn't get a phone call, no mail, no nothing. All right, so whatever you guys recommended to them, they didn't take that advice. All right, I did some research. The people that sold you the land back in 1987 are these people here that are sitting here. We sold you the land for $10 in 1987 as a goodwill gesture and sold it to the county in 1987. 36 years later, you guys are done with the land. You sell it for $1.1 million. So just let you know that, okay? There is, like she said, there was a tractor trailer. They already are using it for commercial use already. They've been doing it behind your back the whole time. They're parking tractor trailers. They're right. The water company trailers are in there. She is right. They blocked the road off for 15 minutes trying to back a trailer in there. That's our main entrance. 15 minutes. One medical emergency. That ambulance has been sitting there for 15 minutes to go by and get somebody for a heart attack. Don't allow this, I'm telling you. You keep a road safe. I'm begging you, Commissioner Jenkins, here's your resident speaking. We know the area. We've been there since 1965, okay? She was saying that the county did, the lawyers told you that they bought it as is. The lawyer even told you that he recommended to them and told them what the land use was. I was a bidder. I was gonna buy it and live in it. I bid up to $200,000 to live in that house. And the staff has told you they bought it as is. They're giving you all the information to make your vote. They bought it knowing that they couldn't change it. When I went to the meeting, Elliot Paul, who did the auction, kept saying time after time and time, make sure you know what you're buying because this can't be zoned any other way. Make sure you know. Okay, so I don't know what other information you guys need, but we're begging you as residents. There's kids within 100 feet of that place playing in the street. They blocked the road off already. They already use this commercial. Go on the internet right now and you'll find out. They have it listed as a commercial building for lease. They're right. They're already reaching out to prospective buyers because they already have it listed as commercial, which is false advertisement. It's not commercial. You guys need to put a stop to this right now. Tell them to get their trailers off that property and quit using it as residential before somebody gets hurt.
Thank you, sir.
Thank you for your time. I really appreciate you guys. Thank you.
Our next request to speak for is Mr. Michael Dooley. Mr. Dooley, good morning.
Good morning. So my name is Michael Dooley, and I'm here speaking in support of this land use change. I understand that, in fact, the commissioners may have my talking points. I am telling you right now that I have revised them from what you might have to condense the time. So everything that I'm saying to you is going to be in the points that you have, but I've reduced some of my comments. A little history. Ridgeway was first created in 1965. Martin County did not have a zoning code until 1967. Prior to our comp plan, our commercial uses were typically designated as R3A, B1, 2, and 3. I state all this to help lay the foundation as to why this property should be changed to GC land use. If one was to look at the plat of Ridgeway, it's interesting to note that the parcel we are discussing originally shows no number. Now has an identifier of 1B. Then the lot next to it starts Lot 1. Why? I believe it was the intent of the creators of Ridgeway to always set aside the properties along the highway for commercial uses. Why else would that parcel be 3 times larger than the parcels to the east? If the intent was to have residential lots on this parcel, the developer would have numbered 3 more residential lots on the original plat. The original plat shows a dotted line east of this corner parcel, along with the parcel to the north and the parcel to the south, both of which are now GC. I submit that when the comp plan was created, there was a Scrivener's error. It would not be the first time that there was an error in the coloring of the plan. I've personally had to address Scrivener errors in the past. It makes perfect sense to change this property from mobile home to general commercial. The historical trend along US 1 and Hobe Sound dictates it. Why? For the most part, the land use along US 1 and commercial at any corner is general commercial. I watched the video of the last meeting when this agenda was brought forward. I want to address the one comment concerning traffic. If in fact there's a true concern of increased traffic, I would suggest the last thing we would want is a residential unit on this corner. Imagine a young family living there with young children. Do we really want children living at the corner of Ridgeway and US 1? I think not. For the reasons above, I ask you to please vote in favor of this request. Thank you.
Thank you, sir. Our next request to speak form is Karen Chicano. I'm sorry? Okay, thank you. How about our next request to speak form is Pat Pratke. Miss Claudia LaRue, I apologize. I was trying. And finally, Miss Rhonda Blackard. Okay. Anyone else looking to address us? Seeing not, we'll have the applicant come for a final comment.
Thank you, Commissioner. Just want to add a couple clarification statements, if I may. I did meet with Mr. Tom Quint following the meeting, and it was here. Yes, it was after the meeting. In discussion with him as to what he expected to see or how we might be able to find some common ground on this piece of land, he was very adamant and said, nope, it needs to stay mobile homes. So there was really no common ground to be found there. Mobile homes are not appropriate on this parcel. Commercial is appropriate. Ridgeway will benefit from the tenants and users on this property. So I did take his phone number. He also has my phone number. We couldn't find any common ground, so we're at an impasse. So that's why we are where we are. Do you have anything to add?
Sure thing. Good morning, Commissioners. Jared Gaylord again. I just wanted to introduce the applicant. It's the Grace family. They originally did own property in South Martin County for residential purposes. Now they own a lot of property for investment purposes. It's also worth noting that one of their limited partnerships, Worldwide Fabrics, was also instrumental in the Loxalucy project. They worked with the Nature Conservancy to sell that property to put it into conservation. So over 110 acres along the Bridge Road corridor is now not fit for development, thanks in part to the Grace family. This morning, I do have 2 letters of support from local business owners I would like to place into the record, from Eric Wessel and also Eric McLeod. I would also like to place into the record some of the marketing material, which goes to some of the information that Mr. Quint had stated, that this property could never be used for anything other than a mobile home use. The marketing material itself says, we assume the changes to the zoning to general or highway commercial per the property contact. It goes on that the subject consists of a freestanding commercial building and is in overall good condition for its age and is well maintained for the use. Furthermore, it states, we assume the subject will be rezoned to general or highway commercial, which permits apartments, hotels, hospitals, offices, financial institutions, general retail, storage facilities, restaurants, and automotive services. And then in summation, in conclusion, it is our opinion that the highest and best use of the subject as vacant is developed for a retail use property. This makes sense to me.
Mr. Gaylord, whose information is that?
This is from the Martin County Board of County Commissioners auction information packet from Elliott Paul. That was what was used to market this property. I understand that my client bought it as an auction property and understood that they needed to rezone it, but it was marketed as something that should be rezoned. And that makes sense given the adjacent uses, right? We have a Broward Motorsports to the north, and we have a Publix to the south. This is fronting on Federal Highway, one of the highest traffic corridors in the county. It makes sense that this should be a commercial use, whether that's community commercial or general commercial. That makes sense to me. One other comment that I did want to address, which was about the sign, in communications with the county and staff during the purchase, there were 2 encroachments, one of which was the Ridgeway sign, which does encroach into the county's right-of-way and also onto our property. There were communications on whether we could work out an easement. My client has not moved that sign to date, and we are willing to either grant an easement or somehow move the sign so that it does not, it's not removed from the property. So we're happy to work with the Ridgeway concerned residents on that point.
Thank you.
Thank you.
Ms. Elder?
Good morning. Elise Elder, Deputy County Attorney. For the record, the document that Mr. Gaylord was reading from was the appraisal that was done on the property when the county was selling it. It was done by an independent appraisal company. I actually spoke to the owner of the company or the person who wrote the appraisal, and that was an assumption they made, not anything that the county indicated. So I just wanted to clarify that was an independent appraisal.
Thank you. Commissioner Smith?
Elise, because I'm always careful of where we are. We're in land use, right? We're not in zoning.
Correct.
Can we, at this junction, and I'm not sure that it has anything to do with land use, but can we talk about the signage at this moment, or does that have to wait?
So you mean the Ridgeway signage? So this is private property that is owned by someone, not the association. So
Oh,
you can talk about.
In the context of, it won't, if the land use change isn't to occur, if that didn't happen today.
Correct.
There wouldn't be a zoning discussion,
Correct.
right? Because one would follow the other.
Correct.
So the reason why I'm asking is because I'm curious and how far I can go talking about the sign relative to land use, which it really has nothing to do with land use.
Correct.
Other than if we don't discuss it at this point, it doesn't get talked about in the zoning conversation because there wouldn't be one if it didn't move forward. If
Right.
it does move forward, then perhaps during zoning, we could talk about it.
So it's a legislative public hearing, so it's based on policy decisions. So if you tie it into a policy decision, whether or not you want to change the future land use designation, it would be okay. Whether or not you change the future land use designation or not, the property owner can require them to remove the sign. Either way, so it doesn't matter, but in that context.
So tell me when I should stop.
Okay, perfect.
Looking at the aerial and looking at our right-of-way maps, the sign looks to be about 60% in our right-of-way and maybe 40% in the property of the owner. Just, and Clyde, you can bring it up if you wish. I think regardless of where we end up in the conversation today, we had an instance like this up in my district years ago with a neighborhood that it was a purchased property that the homeowners association sign had sat in the purchased property for decades. And an agreement was worked out. Can you keep going in closer, closer, closer? Okay, there you go, perfect. So I don't know if my 60-40 rule is right. It looks a little bit, almost 50%, maybe 60. I was even better putting it in blue. So one thing I would hope, regardless of where we end up, is that the owners could either give an easement. Clearly, the county must not have an issue with it being in our right-of-way. It's been there for 50 years, plus or minus, probably. I don't think we've ever asked them to move it in those 50 years, and probably can't imagine that we'd ask them to do so now. I think trying to move it, relocate it out of the parcel would just be more expensive and more problematic than not. And I would hope that the owners of the property could find a way to work with Ridgeway to keep the sign where it's at, because why not? And again, the sign in the neighborhood up in Jensen is still there on the private property, and as much as it was a little bit of a contentious issue with the new building that got built, I think calmer heads kind of prevailed over the idea that it wasn't worth that big of a fight over where the sign was located. So if I didn't break any rules, at least that was my
Okay. That was probably enough. Thank you.
general comment on the edge of
Yeah.
going over the edge. Thank you.
Commissioner Hurd?
Yeah, and my role as the as a county commissioner, my first priority is to protect existing residents. In this case, it's over 900 parcels that have been land used that way and occupied for over 55 years, and also to uphold the law. And the land has been land used, mobile home park, the entire time. I think that these people had the expectation that that would remain. The property, when it was surplused with the existing land use. The owner should have expected that that was going to be the land use that he or she was going to have to work with. So I make a motion to deny.
Thank you. Commissioner Jenkins.
So, I mean, this is not appropriate for a mobile home park. 3 on US 1. We get that. So it has an inappropriate zoning on it now. We sold that property for over $1 million. What is that, 3? Could you subdivide that into maybe 3 lots there? What's a Ridgeway lot go for? $50,000? That's $150,000. We did our due diligence prior to surplusing this property by having an appraisal. The appraisal states in it, as plain as your face, that it's going to be rezoned in some form of commercial form. We made the decision to surplus that property. I would assume some of the basis of that decision was the appraisal. I don't want to go against these good people, but at the same time, I don't want to be back in this conference room having a settlement agreement, which we seem to be pretty good at. So I get it all. And the Ridgeway sign, absolutely. The owner, I'm sure, I somewhat know the owner and his group, and they'll work that out. And maybe we can make that part of a motion. But I just, how can you leave it? It's already an inappropriate zoning, completely. So, in my mind, we don't have a choice. So I'll make an motion to accept staff's recommendation.
Commissioner Smith.
And I also hope for the public's understanding of what we are required to do when we make these decisions. Elise is wincing over there every time we talk. Land use is first. The issues relative to even the signage, and that's why I kept begging for forgiveness of what I was talking about. The zoning conversation would, if a motion passes, comes next, and the constraints and the restrictions relative to what happens with zoning is where that conversation happens, not land use. The question, and Clyde could do a much better job than I will, or Elise could do a much better job than I will, at why do we do land use first? How do we make the decision? What is the basis of making a decision for land use, not to be confused with zoning, because the two really are very separate issues. The land use is a category of use. The restrictions by what you can do with that property are in the zoning conversation, and we are not allowed by law to go into the zoning discussion as part of the land use. Is that correct?
Correct.
You got it.
But you can expand upon that if you will. I want the public to hopefully understand the constraints that we have, that we work with on these decisions. They're two separate, different decisions. One can't be based on the other, as much as we would love to talk about it at this point, because you'd love to think, as the public or anybody watching this, why don't they limit what can happen before anything happens? Because then we have the certainty of what could happen. Unfortunately, under state law, that's not the rules we get to operate under. So how do we get to a land use opinion, or how does our staff get to a recommendation of a land use change, and what is the basis of that we have to vote on?
I'll be happy to try and expand on that, Commissioner. Florida statute, Chapter 163, set forth in the 1980s a program for all of the 67 counties and the cities of the state of Florida to plan for the future. And that required creating a comprehensive plan, and that required creating a future land use map as an exhibit to that comprehensive plan. And that lays out, in general terms, residential shall be here, industrial shall be there, et cetera, around the map. It did not get into, and is not intended to get down into the nitty-gritty specifics of your setbacks and so on like that. And that's why you have a land use map with about 19 different categories, and then the statutes require that the specifics are dealt with in the land development regulations, and attached into, and a part of those land development regulations is the zoning atlas. And the proposed change to the zoning atlas is the next scheduled public hearing here today. And in the land development regulations, you get into the specifics of how much building coverage you can have, how much minimum open space you have on each lot, what's the minimum lot size on each lot, what are the setbacks on each lot, et cetera, et cetera. And you can also create multiple zoning districts for each future land use designation.
The but, though, with what you just said, none of that is a determination or a determining factor in whether or not staff's analysis of the adjacent land uses of the adjacent categories has anything to do with, those are the follow-on issues. But the land use decision cannot be made based upon, I think it ought to be 3 stories, I think it ought to be 2 stories, I think it ought to be 50-foot setback versus 20. That's not how you get there, correct?
Correct.
That's correct.
There's different criteria for a future land use map amendment to evaluate that. And if you look at Mr. Doolin's staff report, it in details goes through the different criteria that need to be evaluated for a future land use map amendment. And the staff goes through those criteria in detail and lists it in their staff report and comes up with a recommendation of approval. If that criteria is not met, then Mr. Doolin would not recommend approval. And in this case, Mr. Doolin or Ms. Carolyn actually went through the process and recommended approval. So you can see that in the staff report.
So that was going to be my next question. Not that you didn't open up your presentation, but staff's recommendation is
Approval.
approval for,
General commercial.
and the LPA's was,
Recommended 4-0 and approval.
and for all of that, and I agree with Harold's comments to the residents, and I appreciate you showing up, I appreciate you commenting, and I fully understand the perspective. But on the land use side of this, I will second Harold's motion, and hopefully we will deal with some other issues if it is to move forward relative to how we can further protect the residents from what might occur.
Commissioner Hetherington.
I'll just say in brief, part of that description, the way you just laid out the legal process is the purpose why 2 weeks ago I said, whoa, stop, tap the brakes, because I didn't feel it was appropriate to ask the questions that I wanted answered in a particular type of hearing. And I certainly didn't want to get us into a lawsuit. So this one's a hard one. It certainly makes sense to have general commercial and not have a mobile home designation on US 1, but it's still hard to tolerate, and I certainly understand where the residents sit. And if it does move forward, then I have a lot of questions on the next step.
Thank you. Given the 2 weeks in between the first time this had come to our attention and today, I've done some research and thought quite a bit about it. I'll be honest that when this original agenda item was in our agenda packet, it would have been like sort of business as usual, approved by staff, approved by the LPA, a relatively small piece of property on US 1. I didn't think much would have turned it into what it has, but it's just another example of how unique this position as a commissioner is. Heard what Mr. Quint had said last meeting. Appreciated that he hung in there the entire day. We went through the process. I did speak to the applicant's representative afterwards and said, look, normally in situations like this, we'll try to work it out with the neighbors. I agree with, there's passion here, no doubt. There's a couple of things that sort of tip it for me. And last time I had voted no because I didn't have all of the details that have come to light since. But with that in mind, the first thing, and Commissioner Smith sort of danced on the edge where he felt was appropriate, but when one of the residents mentioned the signage of the neighborhood, sort of this is where we live, I immediately wrote down in my notes, a sign. Now, I don't know if we can get into the details now or later or whatever, but I understand, your concern and agree. The notices are something that's always very important. It's a legal requirement so that a developer or anyone looking to do anything, sometimes it could be a next-door neighbor looking to do something much simpler. The yellow signs are an indication of something's happening, but a lot of people don't know that. The notices, the reason I believe, and Mr. McCarty can explain, that it was 188 and not more than that, even though the neighborhood is larger. It's meant for a sort of a circle, a circumference of how far or close you are to it. So it might be on one side of the street and not on the other, depending on how many feet the notices are required. I'm sure, look, there was a concern about the fact that maybe the notices weren't sent. That would be a terrible thing. It's much easier to send the notices than to get caught not sending the notices. I mean, they were submitted at the last.
Commissioner Campy, I just looked in the file, and we do have an affidavit from the applicant's representative attesting that they did notify all property owners within 1,000 feet of the subject property on July 1st.
So I was just listening to folks that came here to discuss this with us and check those things off. Now, the other issue is traffic and blocking. That's not an issue that we would necessarily take up as much as the sheriff would take up. I hear the concept of, any truck. I work on a dead-end street in Palm City, and next door to us is a boat manufacturing repair shop, not a manufacturer, a repair shop. Big boats, big trailers, they park them on the street, and then quite often if you're pulling down the street, it's also the street that Palm City Elementary School ends on. And there's a guy with the forklift trying to maneuver gigantic boats in and out and blocks the road. Not for that long of a period of time, but that being said, that's a sheriff issue, not a commissioner issue. And I thought even the other day when this came up, there's a couple of things that sort of tweak this for both the residents and the new owners. If you had asked me, and I've been up here for a while, if you had asked me what the underlying land use for a fire station would be, I would have told you institutional. I would never have guessed mobile home. So that is, and I get the point for the residents, but if this road, Federal Highway, was, some other kind of much smaller kind of road, I could see that. But personally, I don't see having mobile homes right on US 1. US 1 is the busiest road through our entire county. And so for me, and then also there is a little bit of a twist to the story that one of the people that was originally having an issue with this was also one of the bidders on the property, which I didn't comprehend at our last meeting. I think, from my perspective, the reason we moved our firefighters off of that location is that it had basically served its functional usefulness, had basically run down to a point where if I lived behind it, east of it in Ridgeway, I would welcome the opportunity for someone to come in there and breathe some new life into it. When I did have a conversation with the applicant's representative, I said, I would be presenting to the neighbors our landscaping plan, our rehabilitation plan for what this building would look like. Obviously, the sign recognizing and acknowledging the hundreds of homes that are behind it, in my opinion, will of course stay. If anything, it should be enhanced. And if most of it, as Commissioner Smith astutely pointed out, a majority of it's on our property. So as far as I'm concerned, as one of 5, there will be signage for your neighborhood. But putting all that together, I don't see that running 3 additional mobile homes right onto the edge of US 1 is a smart strategy. The other thing that was brought to our attention today for the first time is that marketing material, and I hear my attorney who represents us say that that was presented by the auction company put that out?
I'm not sure who put it out. It was the county got an independent appraisal by an independent company.
Well, I don't think an appraisal company does marketing material. That's
No.
got to have been the auction.
No, that was the actual
Can I
appraisal.
see it?
It was the actual appraisal, because I read the appraisal and I actually spoke to the
Okay, but I'm
appraisal.
talking about the marketing material.
Right, but that's what he was reading from.
Okay.
Tell it, all this stuff. Everybody just stand up.
Okay. Thank you. When we talked about let the buyer beware and due diligence, if I see an appraisal documentation that's stapled to the notification or the advertisement for the auction, that's, to me, sounds like someone doing some homework. And if we did not appreciate or agree with what that appraisal information said, for me, the weirdest part is we were the seller. When I say we, I mean collectively the county. This is not, we're not outsiders in this looking at 2 different issues and we're trying to arbitrate between 2 separate parties. Collectively, we're one of the parties. And so if I was the person that was thinking about purchasing that property for nearly $1 million, and then when you put on all of the extra expenses and things like that, over $1 million, it's not like it didn't say that. It's in the appraisal gives information that it had options. It wasn't like you're buying this and it can be nothing more than what it is. Now, I think there's a lesson to be learned for us, and I think that to Commissioner Hurd's point, and I'll let her have a say next, is the existing neighbors are a priority in my thinking. That fire station, and if it's a water treatment, the green aspect of the water treatment, I get that's very nice, but if they're looking to keep the building as it is, I think there could potentially be an enhancement for the residents that if this building is renovated and the landscaping is redone and the signage for the neighborhood is enhanced to make them to even more of a call out for where people live. I think that even though today it might not seem that way for the folks that live down there, in the long run, this is a better option, in my opinion. Commissioner Hurd.
Yeah, maintaining a mobile home on this parcel is just merely upholding the law for the people who live in Ridgeway and have lived there for over 55 years. And also, commissioners, I know that when we consider surplusing county properties, that we usually are given some evaluation of the history with this parcel. If I had known that the Ridgeway development sold this parcel to the county in order to build a fire station in 1989 for $10, my response would have been very different, very different. I think that's a consideration that unfortunately we were not made aware of.
2 points. One, I don't disagree with your second point about if we knew it was a $10 piece of property that it was ours for decades, that it would have been that situation. However, that ship has sailed. And secondly, in terms of with all due respect to my colleague, who I value her opinion, the concept that it's the law, that it's mobile home. The five of us, it's not like this, the 10 Commandments up here. We change zoning back and forth, up and down. That's our responsibility. Staff makes a presentation and a determination. They have agreed that it can be changed and it fits into the parameters. And then the five commissioners. So to make it sound like you are going to uphold the law and the four of us are going to, or potentially whatever number, are going to break it, that's not true. We had a request to have it changed, and that is our job to review that information. So the concept that you disagree with how it's being changed, I understand. The concept that you are upholding the law makes it sound like those that would support the change are somehow breaking the law is not accurate. Commissioner Smith, and then let's wrap this up.
Just one final comment. I think relative to surplusing land, a lot of lessons have been learned on this. We are constantly challenged that we should remove from our inventory parcels that we're not using if they're not needed, whatever. But as everyone can probably see with this, it's not fraught with unintended consequences sometimes. And
The motion maker?
it should give us great pause when we get these agenda items coming forward again to surplus land. It may seem, just go ahead and sell the piece of property. What difference does it make? It makes a lot of difference, especially to the Ridgeway owners in this case. But I hopefully in the next agenda item, if this passes, we can address some of that issue as well.
Thank you. All right, I'm going to call the question. We have a motion by Commissioner Jenkins for staff's recommendation, seconded by Commissioner Smith. All those in favor?
Aye.
Aye. All those opposed?
Opposed.
Motion carries 4-1 with Commissioner Hurd dissenting. And now the next item is also related to this. It's,
Are you going to do your closed captioning?
no, I want to get this over with just very quick, I think. Public hearing, quasi-judicial number 1, public hearing to consider adoption of an amendment to the Martin County zoning atlas to change the zoning classification for CPA 23-05, 6900 Southeast Ridgeway Terrace. It'll be presented by Mr. Clyde Doolin, and I'm sure assisted by others. It's quasi-judicial, so Commissioner Hurd, do you have any ex parte communications?
If I have any, they've been filed.
Thank you. Commissioner Jenkins?
I have, and they've been filed.
Commissioner Heatherington?
If any, they've been filed.
Commissioner Smith?
I do, and they're filed.
I have some and they've been filed. Is anyone that's going to be offering testimony, please stand to be sworn in? Not lawyers?
Raise your right hands. Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Are there any, I guess the return receipts were submitted already?
Yeah, since it's a continuation, they were submitted, I believe, at the LPA.
Thank you. And there's no interveners?
No interveners.
Mr. Doolin, do you have a copy of your work history and a copy of the agenda item?
I do. It's been provided to the clerk.
Thank you very much. I think that's everything we needed.
Correct.
Mr. Doolin, you are recognized to begin.
Thank you, Mr. Chair. This is 0.65 acre property. The existing zoning is an RT zoning district that dates back to 1967. The proposed zoning is general commercial, which implements the future land use designation that was just voted upon in the last public hearing. There are two potential zoning districts that you can choose from that implement the general commercial future land use designation. One is community commercial, CC. The other is general commercial, GC. This is a permitted use schedule showing the two zoning districts that implement the general commercial future land use designation. The uses are on the left side, and the letter P indicates something that is a use is permitted in a zoning district. As you can see, the CC and GC permit many of the same uses. Major difference would be, for instance, bed and breakfast is not permitted in the general commercial. I'm going to scroll down to, I've scrolled past it. Vehicular use is a use that is permitted in general commercial, not permitted in community commercial. Also, restaurants with drive-throughs are permitted in general commercial, not in community commercial. Those are two very likely differences between those are two permitted uses that you might find on a parcel this small. Some of the other items, like large box extensive impact retail, would only be permitted in general commercial, but that would be very unlikely, probably in a site this small. So I'll be happy to go through any of the permitted uses you'd like to discuss, but that's kind of an overview of the differences in permitted use. So for instance, restaurants are permitted in both, but restaurants with drive-through are only permitted in the GC. As you can see, trade and skilled services are only permitted in the GC, vehicular service, vehicular maintenance, but for instance, veterinary medical is permitted in both. Moving on to some of the standards for the specific use, the development standards. The minimum lot size is the same for both, the minimum lot width, max hotel density, max building coverage. The CC is limited to 50%. The GC is allowed 60% building coverage. The height difference is 30 feet for the CC and 40 feet for the GC. And the minimum open space is less for the GC at 20% versus the 30% for the CC. Structure setbacks are the same across the board for both the CC and the GC. It is completely within your prerogative to make a choice on what is the most appropriate zoning district to implement this future land use designation. The applicant requested GC. The staff recommendation is for GC. However, you have that as your choice. And with that, I will end my presentation and be happy to answer any questions.
Thank you, sir. Questions for staff? Seeing none, applicant's representative.
Good morning. Mike McCarty, McCarty and Associates Land Planning and Design, representing the applicant, address 309 Southeast Osceola Street, Stuart, Florida. We agree with staff's presentation. We request a general commercial zoning designation. It's appropriate to this property. It's consistent with the Publix to the north, which is very large, intense commercial use. And it's also consistent with the Broward Motorsports to the south. We feel this is appropriate zoning designation, and we request your approval. If you have any questions, happy to answer them at this point in time.
Questions for the applicant? Seeing none, any members of the public looking to address us on this topic? Sir.
Tom Quinn, 6940 Southeast Ridgeway. I just want to know, you guys are just finding out we sold you this land for $10. Was there any, it says in the warranty deed that I have, that I pulled up from the county records, there's restrictions, reservations, and easements included in this deal. Did anybody check to make sure that land wasn't supposed to be given back to Ridgeway? Did anybody check what the reservations, restrictions, easements were in the deal? If we sold you something for $10, don't you think somehow Ridgeway would benefit somehow back when you guys are done with the land? You guys pocketed $1.1 million off us for $10. We're poor residents. We're living, we don't have much. All we're asking for is a little street to be left alone. And we can't get that. I think you guys need to check to make sure. This warranty deed, it says right here, Book 4, page 41. Look it up. Make sure you do your due diligence, because there could be a lawsuit like you guys are afraid of, could still come because you guys didn't do your due diligence. Check this out. I'm telling you, we sold you that land for $10. A goodwill gesture. The residents, they have nothing to start with. And then you guys sell it for $1.1 million. It's on record. I asked you last meeting to check with William Snyder, the sheriff, to see why the crime rate's going up. You said he'll be here in an hour. I'll talk to him. What did he say?
I did speak to him. He obviously doesn't know every single street of the neighborhood. He said he would look into it, and he disagreed with some of your
That commercial property doesn't bring in crime.
I didn't ask that specific question.
That's what I asked you, though.
I asked about
All right,
your area.
I'm just saying.
Look,
All right,
let's
I
not-
had no other
Thank you.
thing I can do. I mean, we basically lost. I mean, you guys made your decision. If something happens on the street, a little kid gets hit, killed, whatever, Just remember, it's on camera and everything, okay? Just to let you know.
Yes, sir, you're next. Please state your name again for the record, please.
All right, Matthew Hendrickson, I live in Ridgeway. I know there's a lot of concern with the street and the traffic. If I remember rightly, there is no actual entrance or exit onto US 1. Everything goes through a two-lane street on the side of the building. The fire trucks used to have the same problem going in and out of there. My concern is possibility if they could put an exit entrance out onto US 1, it would alleviate a lot of the problem with the traffic. I've listened to the gentleman, what they're going to use it for. I believe there's going to be a lot of trailer trucks involved in his business. I don't know if they're going to manufacture their water purification stuff on site and ship out of there. But I would like to see if it's possible to maybe put an exit entrance onto US 1 instead of onto the side street, and I think that would solve a lot of problems for a lot of the people. Thank you.
Thank you, sir. I think that's a good suggestion. Anyone else looking to speak to us on this topic? Seeing none, yes, Ms. Elder.
Yes, Elise Elder, Deputy County Attorney. Just for the record, we don't have I don't know the history of the property originally being sold to the Board of County Commissioners, but if you look at warranty deeds, frequently the price of a particular piece of property is not included in the warranty deed, and a lot of times they do put $10. And then the reservation language is also standard because you'll have utility easements or sidewalk easements, so that also transfers with the property. I don't have the history of the sale, but just because the deed says that, does that mean that that actually transpired and it was sold for $10? Frequently, they don't put the price and they'll put $10 because that's just a standard.
So, 1 second, please.
Okay, I just wanted to give the board that information, so we don't have the history, but just because it says that doesn't mean it was sold for $10 is my point.
I appreciate that. Sir?
I can't address what the consideration was for the county when they purchased it, but we did the transaction for when the Grace family purchased this property, and in our title search.
Closer to the microphone.
Excuse me, sorry. Jared Gaylord again for the record. We did the transaction for when the Grace family purchased this property, and there was no restrictive covenant or anything like that in the record that stated that this shall only be used for county municipal services or as a fire station, and if not, then it will revert back to Ridgeway. So that didn't exist in our title search. And also, I just looked at the deed, and the recitals are standard recitals, things of record, not any specific deed restrictions that it shall be only used for a fire station.
Thank you for addressing the issue that was rightfully brought up by a resident. Okay. Commissioner Hetherington.
I saw your table, Clyde. I just think that this particular location, giving, very good point, it does not have an access onto US 1. Can an access be made onto US 1 on this parcel?
So that would be a question for when a site plan came forward or a development application came forward. It's not something we're talking about today. This is really just the piece of property, what's permitted on the property, not the actual mechanics of the property.
It's just very close to Ridgeway. I think it makes more sense to have community commercial on it, which would prohibit drive-throughs. And to me, that seems to be a little bit more of a compatible use there with the neighbors so close. So I would rather see it have a community commercial designation.
Commissioner Smith.
To the driveway idea question, we've had multiple parcels on US 1 that are not dissimilar to this kind of a parcel. We have one probably a mile north of here that the residents, maybe 2 miles, very much did not want their entrance road being used as an access point. Now, in that case, well, and even in this case already has connections to Ridgeway. In that case, there was an easement that was facilitated through the property since its inception. Nor would FDOT grant the parcel access given its proximity to a collector or whatever Ridgeway is, or an arterial. And the separation between its access and other access, it just becomes incredibly complicated. Again, that's all site planning, but if the building is to be reused or rehabbed in its existing condition facility, the site planning wouldn't be an issue for us at this point until there was a demolition done or a proposed change of use or something that was going to be discussed. And that's a whole nother process that would have to go through that isn't part of whether it's the right zoning or not. The conversation I had with the applicant over this was another alternative that's not been offered because the applicant hasn't asked for it. And I only throw it out there for consideration because of the conversation in terms of the issues relative to the site, to the neighborhood. There is a third option, and that's doing a PUD. And the applicant hasn't asked for a PUD and isn't proposing to do a PUD. But if we had a PUD, there would be a lot more we could put into the zoning requirements of a PUD that you won't get out of community commercial or you wouldn't get out of general commercial. The signage issue, that'd be a starting point. I mean, you could certainly deal with the PUD agreement on the signage, and whether the applicant voluntarily wanted to do an easement or do some carve out for the signage, that's a whole nother story. Setbacks and buffering from the adjacent residential unit that is the mobile home on its adjacent side. All sorts of things that we could negotiate in the PUD that could make it, for intended or non-intended use in the future, we could significantly limit and control relative to that. That's just a thought that the applicant, I didn't get a yes or a no in our conversation. I probably got more of a no than I got a yes or even consideration. But I throw it out there because of the situation I think we have with the neighborhood that makes it a very difficult thing to do. If that doesn't work, I am supportive of the community commercial. I think that puts a little bit more restriction in place than what the general commercial does. But for me, a PUD still would give us a lot more flexibility relative to how we could protect the site.
Thank you, sir. Commissioner Jenkins.
So quickly, just going through the use chart. Can't build a hospital on CC. Don't think we're... outdoor amusements, probably not going to do that. Driving range, can't do that. Pain management, probably not going to do that. Drive-through, yes, absolutely. If I was a resident, that would be my biggest fear. So I get that. Vehicular sales and service. Wholesale trades and transportation services. That's the only difference between CC and GC. So I think that CC would be an appropriate, I completely agree with Commissioner Heatherington and Smith, so.
Okay.
Chairman, may I address the board?
Second, please.
Yes, sir.
This is a quasi-judicial. We're going to go through the steps to make sure we're handling it appropriately. We've heard from staff. We asked staff questions. We heard from the applicant. We asked the applicant questions. We heard from the public. We've had a little debate. Now we'll have final comments from either staff or the applicant. Mr. McCarty, it's your turn.
Thank you, sir. Mike McCarty Land Planning for the record. Thank you, sir. Appreciate that. And yes, Commissioner Smith, you're 100% correct. FDOT would be an issue as far as a direct access point onto US Highway 1, giving the proximity of Ridgeway, along that frontage, and the mere lack of frontage for this .65 acre parcel. So you are correct in that statement, sir. I agree with that. And yes, Mr. Smith, PUD could possibly be an option, and I thank you for forward thinking and in that mindset of a solution. Respectfully, currently, what we are trying to do is utilize an existing structure, and the PUD is more appropriate if we had full intentions at redeveloping this site, which currently we do not. If in the event we do want to redevelop the site, fully agree, and if we did pursue that, we would be before you in the form of a PUD. Now, I hear the board, I hear Ms. Hetherington and Mr. Jenkins with regard to the uses permitted in commercial general versus the community commercial. We recognize the residents in the immediate area and some of their concern. So therefore, I will make a gesture in good faith that yes, we will accept a community commercial zoning designation as a common ground finding with you, the board, and with Ridgeway residents. Thank you.
Thank you, sir. Commissioner Smith.
Mike, the only thing I would suggest, and I appreciate your comments, thank you. If community commercial is granted, the scale of this property, the size of this property probably would not come back to the board for a site plan approval if it met all the requirements of community commercial. It wouldn't reach the threshold of doing that. And there's nothing that allows us there's nothing in this approval of zoning that would give any kind of a conditional agreement in straight zoning for you to come back with a PUD if a new site plan were to be brought forward. Right? At least, there's nothing.
Right, no, it wouldn't come back, probably.
No, but there's nothing that we can bind them through the approval of this zoning.
No, like to require them to
Come back
grant
with
an
a
easement or?
No, to come back with a PUD if they were to change their site plan.
No.
So it's not a hesitation. It's a little bit of I would really rewind this clock in many ways and do things very differently if we were back at the beginning of all this. But it's not that I disagree with what you said. It's just that you won't have any requirement. Your owners won't have any requirement to come back to us for anything if you get your CC and in terms of a PUD. And even if they sold the property 10 years from now, it still would take with it CC and a new project that came forward and said, gee, we watched your hearing 10 years ago and that all sounded really nice, but we want to do X that is perfectly permittable and allowable if we follow the code and we follow the land development regulations in CC. There's still no requirement for that site plan to ever come back to us.
You're correct, and if that was on my part that I misspoke, my intent was that if in the event we wanted to pursue a use that was not permitted in the zoning designation, the straight zoning designation, whether it be community commercial, let's say, that we would have to come back in the form of a PUD if we wanted to do a use that was not permitted within community commercial.
And that's
Yep.
fair assessment?
Yes, sir.
I'm just letting the public know, and in the conversation, this is the only place we get to talk about this. We don't get to, we can meet with staff and talk about it, but the five of us don't get to meet and talk and have that conversation. So I just wanted the board to know from my perspective what the conversation I had with the applicants were relative to what I thought we could put more controls in place if we wanted to.
Thank you, sir. Mr. Doolin, anything from staff?
No, sir.
Okay, we've heard from everybody. It's back to the board. It's a legal process. I want to be very careful to follow the steps properly and not take anything out of order. So you had an opportunity to address this, and you did. I'm sorry, that was your chance. I can't, because then I understand that, but that's just the way that the system is. I didn't design it. I'm just following it along as the chairman. I want to make sure that neither side is put in a position to have some kind of legal advantage. That's why we're trying to follow the system exactly the way that it exists. And there's been most often an agenda item doesn't get two separate meeting date hearings. So this has been thoroughly vetted. Still back to the board. Commissioner Jenkins.
So I will move approval of CC with the comment that we would encourage the owner to work with the Ridgeway community to make sure that sign that's been there for 50 years remains, or enhanced, and enhanced, yeah.
But for clarification, that doesn't impact the motion, correct?
I guess that was just comment, but.
Thank you.
Why, because it can't?
Correct. You can't contingent the zoning on granting a different property owner a right.
Highly recommended.
So
Yeah.
it would just be based on this application on
encouraged.
this property.
Got it?
I said encouraged. Yeah.
Okay. We have a motion now.
I'll support the community commercial.
That's what I did.
Second.
Yes, so she's seconding your motion. Okay. It's been an interesting agenda item over the last 2 meetings. I would also strongly encourage that the new owners of this property be as neighborly as possible. It behooves you. Many of us have been up here a long time. I shouldn't be the one to tell that when you get along as neighbors, it makes everyone's lives easier. I personally envision this very old and sort of antiquated facility that the county used as a fire rescue station for a long, long time, having some new life breathed into it with landscaping and rehabilitation of the site. I am a strong believer that the residents deserve that recognition of their signage that has been there. As Commissioner Smith mentioned, a majority of it seems to be on our property, and that would be the first step to show the existing residents that you're going to be neighborly. I see some head shaking, so I think that it's not like some magical recipe. Getting along with your neighbors benefits everyone. And with that, I think that the CC, eliminating some of the more aggressive of the uses, especially for such a small piece of property, is the right thing to do. So with that in mind, we have a motion by Commissioner Jenkins for CC, seconded by Commissioner Heatherington. All those in favor? Aye. All those opposed?
Opposed?
The motion carries 4-1 with Commissioner Hurd dissenting. Thank you very much. We're going to take our closed captioning break now, and we'll be back in 10 minutes. Thank you.
Thank you, members of the board.